So I have an update for you in the Suppressor Freedom lawsuit, which aims to remove a statewide ban on the purchase and possession of suppressors. So let's break down what is happening. But really quick before we jump into this video, if you agree that suppressor bans need to be done away with, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Kershaw Knives. Kershaw makes amazing knives. I was just at their facility here in Oregon. I got to tour their facility, see them make all the knives. They make about 500,000 American-made knives every single month from that one facility. Again, amazing company. They support us here on the channel. They're Pro 2A. And right now, if you go to their website and you order using the code ARMED40, you can get 40% off of your order. So again, check them out, use that code, and thank you again to Kershaw Knives for sponsoring and supporting this content. As I mentioned in the intro, in this video, we're gonna be discussing two lawsuits which aim to remove a statewide ban on the purchase and possession of suppressors. These cases we're gonna be talking about in this video are Morse versus Raul, and then also Anderson versus Raul. These are two cases which were filed in the state of Illinois in a federal court and a federal district court, and they essentially aim to remove the state of Illinois and their ban on the purchase and possession of suppressors. Illinois, like some other states, have bans on the acquisition of suppressors, and a lot of other states also have various bans on other NFA items, like California, which essentially has an outright ban on the acquisition of certain NFA items, SBRs, SBSs, and then also suppressors. So this lawsuit here in Illinois is critical because it's challenging a state ban on NFA items, essentially here a ban on the purchase and possession of suppressors. That's what makes this lawsuit very critical, because it's one of the first ones in the nation which is challenging a state ban. And of course, if a court rules in our favor, it would be the first time that a state's outright ban on an NFA item is actually struck down, a suppressor ban is struck down, and then that would impact a ton of other states that have statewide bans like California and others. Now, currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that the suppressors here are not arms and therefore are not protected by the text of the Second Amendment at all. Therefore, the state of Illinois is arguing and requesting that the judge here grant a judgment on the pleadings, essentially in the state's favor, and then throughout the entire case, dismiss the entire case and rule in their favor. Because of this current motion, the court has stayed all other proceedings in the case and is moving towards deciding the case on a judgment on the pleadings. The plaintiffs are attempting to avoid having the case thrown out by adding additional Pro 2A cases like Miller and Duncan and other cases coming out of California. And then also now, because of what the Supreme Court recently did in a bunch of the Illinois rifle ban cases, I would also suspect that there are going to be arguments based on what Justice Thomas just said in his statement when all those Illinois rifle cases were sent down. This lawsuit is very important because it uses the Supreme Court's recent ruling in Bruin to attack a state ban on the purchase and possession of suppressors. Now, in Bruin, the Supreme Court issued an opinion authored by Justice Thomas, which struck down New York's May issue CCW licensing scheme, and it found that that law there was inconsistent with this nation's history and tradition. Now, one of the primary findings of Bruin was that the government, the federal government or state government, bears the burden to prove that their restrictions or their regulations are based in the history and tradition of our nation. This lawsuit here aims to finally make a state like Illinois explain how their outright ban on suppressors is consistent with both Heller and now also Bruin. In the Anderson lawsuit, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. Now, this is important because it's been well established now that modern arms are in fact protected under the Second Amendment, and it's not just muskets and other types of firearms that existed at the time of the founding which are protected. The Supreme Court stated expressly in Bruin that we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. So the argument that suppressors are not protected since they did not exist at the founding is irrelevant, and again, that's being pointed out here by the plaintiffs. The plaintiffs in both of these lawsuits argue that a suppressor is not dangerous and unusual, and the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Also, the fact that these are regulated by the NFA does not inherently make them dangerous and unusual. And the argument really is that these are in common use for lawful purposes. They are owned in the millions. Millions of people own these types of items. They use these items for lawful purposes, and therefore they're in common use for lawful purposes and cannot be outright banned by a state like Illinois. But now in these lawsuits, the state of Illinois has filed a motion for a judgment on the pleadings. The entire motion is based on the state's argument that the cases here should be thrown out because suppressors are not arms protected by the text of the Second Amendment. Now, for those not aware, a motion for a judgment on the pleadings is a motion made under the Federal Rules of Civil Procedures. It's a 12C motion. Essentially, it's used to attack the sufficiency of the opponent's pleadings and essentially the viability of their underlying claims prior to a true trial. So prior to this fully going to a trial, it's a motion that one of the parties can file to try to dismiss the entire case and essentially challenge the pleadings and just show that they were insufficient and therefore the case should not move forward. And if a party wins that type of motion, well, then those claims are dismissed by the court, and oftentimes it can actually prevent any new lawsuit of the same type of claims from being brought going forward or anything new from happening on the similar type of claims. So the state of Illinois is trying to get this suppressor lawsuit thrown out and prevent any future challenges to this type of restriction. Now, in their motion, the state of Illinois argues that plaintiffs raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm, according to Illinois. So they argue they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. They go on to argue that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer to them is not itself used to cast at or strike another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. Again, these are all the arguments that the state of Illinois is making for why they can completely ban these items. And then they go on to say that, and while some people find silencers useful, they are not so critical to firearm ownership that firearms cannot be used effectively without them. So also, this is an interesting argument that's been made not just in this Illinois case, but a lot of other cases where they try to say, yes, we're banning this one item. This one item is not so imperative for self-defense. You have other options. For example, even in the famous Heller case, you had DC arguing, well, yes, maybe you don't have access to handguns, but you have access to rifles for self-defense. Therefore, handguns are not super critical for self-defense. You don't need them for self-defense, so don't worry about that. We can ban them. Similar type of argument that Illinois is making here with suppressors, where they're saying, hey, you can still use firearms without suppressors to defend yourself. Therefore, we can ban silencers. Now, there's two interesting points with this. First, obviously, they're completely avoiding and discarding all the federal laws which are regulating suppressors under the NFA and treating them as actual firearms. Federally, these are regulated as actual firearms, so they avoid that. They try to ignore that. And second, they gloss over the fact that the Second Amendment does not protect just like projectiles or weapons that shoot projectiles. It covers people's conduct. It protects critical activity. It also protects other types of arms. It protects body armor, helmets, things like that, anything that someone could take upon themselves for self-defense, and other types of arms as well. Now, again, what was interesting about this case is now it's moving towards a judgment on the pleadings. And we saw this kind of stall out for a bit because ultimately what was happening is a lot of the arguments here in the suppressor case in Illinois are also tied to a lot of the rifle ban arguments, the challenge to the Protect Illinois Communities Act, or the PICA. The lawsuit here is tied in some ways to that. Now, ultimately, like I mentioned, all of those cases were denied review by the Supreme Court. In an 8-1 order, all those Illinois cases were sent back down. They were denied review. Only Justice Alito would have granted review to those rifle magazine ban cases. But you did get a statement from Justice Thomas essentially saying that he agrees that this issue of rifle bans and magazines bans statewide by a state like Illinois is a critical issue that the Supreme Court needs to review. They just want a final merits decision. So now that those have been sent back down to the lower court, and then there Judge McGlynn is moving all those rifle magazine ban cases towards a final review, now this Illinois case is moving forward once again. We've got a notice from the court there in this suppressor case that there is going to be a hearing taking place very soon on August 21st of this year. There's going to be a conference about what's going on in this case, how is it going to proceed forward, and maybe when it's going to proceed forward to a hearing. So again, that's what's going on with suppressors. If you guys have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.